Welcome to Upholding the Code and Standards, Interim Suspensions and Administrative Orders. At times, cases may proceed in a manner different than a typical investigation, such as situations involving an administrative order or an interim suspension. Administrative orders are one situation where this might happen. For example, if you clearly refuse to participate in a CFP board investigation, or fail to timely acknowledge receipt of a notice of investigation, or fail to address a notice of failure to cooperate, or fail to file an answer to a complaint. You will be in default, and Enforcement Counsel may seek an administrative order to address the situation. This would happen without going before a DEC hearing panel. Instead, a motion for administrative order would be sent to you and to the Disciplinary and Ethics Commission's counsel. The motion would specify whether Enforcement Counsel is seeking an administrative suspension, bar, or revocation. You would have 14 days to oppose the motion in writing, and DEC counsel would decide the motion. If you are subject to an administrative order, you may not use the CFP certification marks or hold out to the public in any way that you are certified by CFP Board. If you are subject to an administrative order of suspension or temporary bar, the procedural rules allow you to seek reinstatement. We'll discuss that process and its limits more fully in the next video. Another different kind of proceeding is an interim suspension, which can be brought either on an automatic or a discretionary basis. The interim suspension tool is used in extraordinary cases involving serious matters. It suspends an individual's CFP certification immediately, while Enforcement Counsel completes its investigation. An automatic interim suspension may be used for serious felony or misdemeanor criminal convictions, as well as a civil finding involving fraud, theft, misrepresentation, or other dishonest conduct, or professional discipline resulting in a bar or other equivalent sanction. Automatic interim suspensions happen without action by a hearing panel or the DEC. Discretionary interim suspensions are somewhat different. If you were subject to a serious criminal or regulatory charges, or engaged in conduct that reflects adversely on your integrity or fitness or on the certification, Enforcement Counsel could decide to seek a discretionary interim suspension. In that case, the procedure is for Enforcement Counsel to file a petition for an interim suspension order with the DEC that will be reviewed and decided by a hearing panel. You would have 14 days to oppose the petition in writing, and DEC counsel would determine whether the hearing panel would hold a hearing. Enforcement Counsel has the burden of proof, but if DEC counsel schedules a hearing on the petition and you don't attend, the hearing panel may presume that the petition's factual allegations are true. The hearing panel considers whether your conduct or alleged conduct reflects adversely on your fitness as a CFP professional, whether the conduct or alleged conduct likely would result in a suspension or greater sanction under the sanction guidelines, and whether an interim suspension order would be in the public interest. While an interim suspension order is not subject to appeal, if facts change after it has been issued, then respondent may seek to have the interim suspension order vacated. You can learn more about these topics in the Handbook for Respondents and the Procedural Rules available on our website.